Hello, I'm Jen Lee with Jen Lee Law. And I was really excited this week when I saw that John Oliver was doing last week tonight and had a bankruptcy portion of the episode talking about bankruptcy and things like that. However, as I watched it, I was a little bit disappointed in some of the things that were said. However, I was very excited to see that there was some good information there as well. So I thought it would be fun to play the video and I have my comments interspersed with the John Oliver video. Keep in mind, this is John Oliver. Adult language is used. Please be careful if you care about that around your children. It's not safe for work or children. Here is the video, and I will cut in as I see fit.
Moving on, our main story tonight concerns bankruptcy. You probably know it from being the worst possible outcome on Wheel of Fortune, aside from hugging Pat Sajak or winning a Mitsubishi Mirage. Or maybe you're familiar with it through ads for bankruptcy lawyers like this one.
Once upon a time, there was a fair maiden named Mary. Mary lived a storybook life until her Prince Charming was smashed from his steed. Then her castle came under siege, and the cries of assault were vexing. Her champion had been gravely injured, and a pox had fallen upon her house.
I've helped thousands of clients like Mary, and I can probably help you get a fresh start.
Wow, there is a lot there. From an unmarked van fully mean-girlsing Mary's husband, to him surviving what appear to be surprisingly minor injuries, to that lawyer claiming he's helped thousands of clients like Mary, meaning that in the Chattanooga area there are somehow thousands of women who've watched their husband get shit-stomped by a cargo van and then take what can only be described as a Gatling gun of mail to the face. If that is true, they've got a way more lucrative lawsuit than a bankruptcy case.
Okay, I'm gonna jump in real quick. Bankruptcy attorneys, this example notwithstanding, tend to be very helpful people to know. And I would say that I help regular everyday people. There may not have been a huge catastrophe that took place, but you don't have to be shot in the face with a bunch of mail in order to talk to a bankruptcy attorney and figure out what you can do with things. So the commercial was very over dramatic, and I have a problem with such over dramatization of bankruptcy because it doesn't have to be this crazy stressful thing that you went through that you can pinpoint. Sometimes it is, but regular everyday people can benefit without having to have their husband hit by a car and have all of this mail come out of their mailbox. Let's keep going.
What that ad is promising, though, is really attractive. A fresh start from your debts. And it's something a lot of people have turned to. Over the past decades, the number of personal bankruptcies filed each year has ranged from about 800,000 to 1.5 million. And many worry that once the current pandemic assistance stops, more and more people will need the type of help that bankruptcy offers. Because very basically, bankruptcy is a legal procedure by which those who are deeply weighted down by debts can get out from underneath them and then have a chance to start anew, which is good. Although it does come with some consequences. It will be on your credit report, and there tends to be some social stigma attached, as exemplified in this clip from Shark Tank.
Jeff, I understand your decision to go bankrupt. Cleans the slate. But it carries a weight. You'll never have a bank, Jeff. Ever.
Lies, lies, lies. You will have a bank. You will have lending. The idea that bankruptcy is somehow the end of your future is so ridiculous. I can't even, but let's continue watching.
To me, you're radioactive.
There are a million people out there who are going to get the wrong message from what you're saying.
No, they're getting the right message. They should not go bankrupt.
Well, hold on, because that is a terrible lesson. And you, Kevin O'Leary, I hardly want to be calling someone's decisions radioactive, given that you invested in companies with business models like put your face on a potato, look like an idiot on a unicycle, and Toygaroo, the Netflix for toys whose mascot always looked like it was searching for a place to take a shit. And, which interestingly, filed for fucking bankruptcy. So I'm sorry, Kevin, but to me, that makes you radioactive. I'm out. But that broad brush stigmatization is common and completely misguided. Because bankruptcy is not solely caused by bad decisions. It's often caused by bad luck, unavoidable challenges like job loss, divorce, surprise medical bills, or perhaps even, a once-in-a-century global pandemic. And despite bankruptcy often being characterized as an easy out, the way it's currently set up, it's sometimes not an out at all, as this couple learned.
Before you're done and over with, you're definitely looking to spend at least $1,000 to claim bankruptcy. We don't have $1,000.
Okay, I'm going to chime in here because this is one of the biggest misconceptions about having money to file for bankruptcy and needing $1,000 to $3,000 or $4,000. You're going to hear in a second how much debt this couple has. And sometimes you don't need bankruptcy. If you have no assets and you have no income, you don't even need a bankruptcy to protect you from, because a lot of times you're trying to protect yourself. However, part of a good attorney's job is helping you figure out what your life looks like as you're filing and afterwards. Most of my clients can afford my legal fees because we go through all of this planning to figure out what their monthly minimums look like versus what they're getting, what they're shedding as part of the bankruptcy. So for example, really quick, let's say I have a client with $50,000 in credit card debt. Their monthly minimums are probably around at least $1,500 a month that they're paying in monthly minimums. So by the time they stop paying their credit cards, they have $1,500 a month that they wouldn't have had before that they can now pay attorney's fees with. They can catch up on their rent. They can do all kinds of things because money is not going towards that debt that's going to go away in the bankruptcy. So keep that in mind as you're listening to people talk about the cost of bankruptcy.
So
you're telling me you can't afford.
We can't
to
afford
go bankrupt.
to go
Correct.
bankrupt. Yet we're $50,000 in debt. So what do we do?
Yeah, a lot of people can't afford to go bankrupt. A true sentence that fundamentally doesn't make sense. So given all of that, tonight, let's take a look at personal bankruptcy. Our modern bankruptcy code was enacted in 1978. Interestingly, around the same time that the credit card industry began to enjoy a period of steady deregulation, which worked out very well for them because they marketed themselves aggressively, and during this time, consumer debt began to sharply rise. And what the industry clearly wanted was people stuck in a lucrative cycle of minimum payments, late fees, and interest hikes. What they didn't want spoiling that was people cutting the cycle short.
Listen to this very carefully, because the stigma around bankruptcy is perpetuated by the people that want to keep you in debt and in this cycle. So listen to this timeline very carefully.
Through bankruptcy. So by the late 90s, they were lobbying senators like Chuck Grassley hard to curb what they framed as bankruptcy abuse, basically arguing that people who could afford to pay were using bankruptcy as an easy way to not pay bills and then pass the costs on to the rest of us. And Grassley seemed more than happy to repeat some of the industry's talking points. But years of lobbying by the credit card and banking industry ultimately resulted in a hugely significant 2005 bankruptcy reform bill, which made it far more complicated to file for bankruptcy than it had previously been, which in turn made it far more costly, which meant many people ended up in a situation where they couldn't afford to go bankrupt. And to understand our current system, a key thing to know is that there is not one main kind of personal bankruptcy. There are actually two. Chapter 7.
And I would argue that there are three: Chapter 7, Chapter 11, and Chapter 13. But Chapter 7 and 13 are the most common for individuals.
And Chapter 13. Chapter 7 is what you commonly think of as bankruptcy. Your debts are mostly wiped out, and while you can hold on to a few essential assets below a certain threshold, the rest can then be sold to pay off your creditors.
Just chiming in here, I'm in California, and very few cases are cases where the trustee sells any assets. With our homestead exemption in California, in the Bay Area, you can keep up to $600,000 of equity in a house and still file for bankruptcy and keep the house. So you have to be really careful with what you think minimal assets are, because you need to talk to an attorney in your state.
It's a few months to complete, but then you do get your chance at a fresh start. Chapter 13, however, is different. That is more of a reorganization of debt. Basically, your finances get examined, to work out how much you can afford to pay into a repayment plan for 3 to 5 years. And if you make all the payments in that plan, at the end of it, your debts do get discharged. And this does have its benefits. You don't have to give up assets like a house or a car. But, and this is a huge but, if you miss even one payment, your case could be dismissed and the whole deal is off. You're essentially all the way back to square one. And
So I'm going to stop this right now. Chapter 13 is a very, very creative and flexible tool. If you miss one payment in a Chapter 13, your case does not get dismissed automatically. It doesn't just get, okay, you're done. This is why you have an attorney for Chapter 13. And in a few minutes, we're going to talk about how expensive Chapter 13 attorney's fees are. You have an attorney the full 5 years or 3 years of your plan. And it is very reasonable to modify a plan, to skip payments when unexpected expenses come up, to modify your plan to either lower or increase payments, depending on what's going on with your situation. And this idea that if you make one mistake, you're out of Chapter 13 is, this is so wrong. I can't even, like, I can get in a soapbox right now and tell you how wrong he is about how Chapter 13 actually works.
The comfortable fact is, this happens in most Chapter 13 cases, because only a third actually make it all the way to discharge.
Okay, stopping again, because he's right that about a third make it to discharge in Chapter 13. There are reasons to file Chapter 13 cases that do not involve getting a discharge. For example, a lot of times to stop a foreclosure sale, to get a loan modification, to reorganize debt that may not be dischargeable, you can use Chapter 13 in a good faith attempt to reorganize without ever getting a discharge in a Chapter 13. So this idea that the only measure of success of Chapter 13 is a discharge is severely misguided, and it's really bad information to be giving out to everyday people who may not be able to determine whether this is accurate or not.
And Chapter 13 is also actually much more expensive to file, because while attorneys charge on average about $1,300 to file Chapter 7, for Chapter 13, they generally charge about $3,800. So you might be thinking, well, if Chapter 13 is more costly, more difficult, and less likely to get you a genuinely fresh start, why would anyone choose it?
Okay, I'm cutting in right here because Chapter 7, attorneys set their own fees generally for Chapter 7. Some courts have their guidance that they give for Chapter 7. And $1,300 is actually really on the low end. If you're going to hire an attorney who's going to work with you for up to about 10 hours on your case, $1,300 actually doesn't pay a normal hourly rate for an attorney. So keep in mind, when you hire someone and you're working with them to do a bankruptcy, you want something that's accurate, correct, someone who knows your situation. It's not just filling out forms. Chapter 13 is a 5-year client engagement. The courts oversee all of our fees for both Chapter 7 and 13. They look at every case to make sure that we did not gouge clients or overcharge. We have to disclose in every single case how much the client, the debtor, is paying to us. So this idea that it's super expensive, if I have a client with $100,000 of debt and I'm able to resolve that for $2,000 or $3,000, if you went out to the marketplace and you were going to invest in a stock for $3,000 and you were guaranteed a $100,000 return, would you not take that? So you have to look at the value that's being provided and not just, oh my gosh, this is a one-time expensive payment for things. And if I seem a little heated, it's because I really care about my clients and getting them the right deal for their particular situation. And whenever people start throwing out how expensive it is, you have to look at what you're getting for that cost. So take it with a grain of salt. And of course, I'm an attorney, so I'm going to defend attorneys. And there are bad attorneys out there in every industry, not just bankruptcy. But you also have to be able to understand what you're getting for what you're paying.
Well, for some, it might be the right fit. Remember, it gives you a chance to keep your house, which you might need to live in, and your car, which you might need to work. But for many, many more, Chapter 13 despite costing 3 times as much in the long term, can actually seem like the better financial option when you file, because Chapter 7 generally requires you to pay lawyers up front, whereas Chapter 13 can be different, as law firms can be eager to point out to you.
Is debt constantly on your mind? Are you looking to get a fresh start financially?
Okay, I can't even listen to this commercial. These commercials that prey on the idea of, you need a fresh start and oh my gosh, this is so overwhelming. Talk to people like they're normal people, not that they're watching late night television looking for a, get out of jail free card, or you can settle your debt for pennies on the dollar, which is a settlement scams. And you're going to hear him talk about no money down Chapter 13s in a second, and I'm going to cut back in at that point.
Then call the bankruptcy attorneys at Wooten & Wooten. We even offer a no money down Chapter 13 plan.
Okay,
I'm going to cut out John Oliver because this is more fun. No money down Chapter 13 plans are a really bad idea. If an attorney is offering a no money down Chapter 13, there has to be a really good reason why the client, the debtor, doesn't have any funds to pay for at least a small amount of the fees up front. Yes, you can put attorney's fees into a Chapter 13 plan, and when you make your payment to the trustee each month, you turn around and the attorney gets paid a portion of that. And that's a lot of Chapter 13 plans have that because you're paying the attorney over the time they're representing you. However, if someone comes into my office and they have zero money in their bank accounts and they're going to propose a repayment plan, my first thought is, how are you going to afford a repayment plan? You have nothing to be able to do that. And so I don't do no money down Chapter 13s because the reason for filing a Chapter 13 has to be clear. Most of the time, someone has a house with a mortgage that may be in foreclosure. There are taxes. Some taxes you can get rid of in bankruptcy, but you have taxes that can't be discharged. And Chapter 13 is a fantastic tool for stopping penalties on taxes from accruing and being able to get into a payment plan that's forced for all creditors, no lawsuits, that kind of thing. It should not be used for people who qualify for Chapter 7 that can't afford their attorney's fees unless there is a wage garnishment happening or something that's preventing them from being able to even function. So John Oliver is going to go on and on here about money sucking attorneys who are putting people into Chapter 13s, but find out why you're going to go into a Chapter 13. There should be a really good reason for it.
Get the fuck out of my void, Wooten. I know I don't technically own the concept of sad white emptiness. Jared Leto's got the market covered on that one. But I will be damned if I let this adult who looks like he just made a wish to be big steal my whole vibe. But the point here is, if you are already in a bad spot with your finances, which you probably are if you're considering bankruptcy, no money up front might not just sound good, it might be your only option. And there is something else that can significantly limit the help that bankruptcy can provide, because there are whole categories of non-dischargeable debts, debts that even bankruptcy cannot get rid of. You typically can't wipe out debt from criminal penalties, taxes, or child support through bankruptcy.
So you can wipe out debt for taxes. You have to have a good attorney who can run the analysis to wipe out taxes, but that's a really common misconception. Also, Chapter 13 that John Oliver is railing against is very helpful for getting caught up on child support, and you can pay that back without paying back other credit card debt that you discharge in a Chapter 13. So the things he's talking about are non-dischargeable, actually are solved by Chapter 13, which he thinks is useless.
See, and there is another massive category, as this woman learned.
31-year-old Radmila Sulimonova graduated with a master's from New York University in 2008, during the depths of the Great Recession. Jobless, she quickly defaulted on her $80,000 student loan bill.
Oh, well, I'll just file for bankruptcy like everyone else is doing, ha ha ha. And then you realize, no, the only way to get away from your student loan debt is to...
Seriously, I'll just get my graduate degree and file for bankruptcy like everyone else does. Really?
Hi.
Yeah. And to communicate just how bad student loan debt is as a generational dead weight on millennials, I guarantee you, anyone with student loans watching this right now heard $80,000 and thought, yeah, I don't know, I've heard much worse. Because yeah, she could have bought this entire 3-bedroom, 2-bathroom house in Indianapolis, but who really needs a place to live when you have a framed 8.5 by 11 piece of paper with your name on it? That can, just like a house, keep you safe from the rain. And if all that weren't bad enough, our current system adds insult to injury through mandatory credit counseling courses, which can be exactly as patronizing as they sound.
Okay, he totally has this right. This is my favorite part of this whole episode, talking about this stupid credit counseling class that they make individuals take before they're eligible to file for bankruptcy.
Even bankruptcy judges have called them inane and a procedural hurdle without value or consequence, with one even noting a course referred participants to the local library for resources on bankruptcy and recommended they seek a job making higher wages. And I'm sure they had never thought of doing that before it was very cleverly.
I've had clients who the suggestion is to cut their cable bill or to meal plan better. And by the time people are considering bankruptcy, cutting your cable bill and meal planning is something that they've already thought of and tried to do.
Pointed out to them. And if it seems that these courses may have limited value, one that we found online even seemed to reluctantly acknowledge that fact.
Your attorney may have gone over your particular situation with you in their office already. Perhaps they explained why credit counseling will not work for you. Many debtors, therefore, believe that this mandatory credit counseling exercise is pointless. We hope instead you will take a more positive view of this mandatory course.
Oh, you hope so, do you? That's basically an admission that the whole thing's a waste of time. Although, quick question here. Why is the attorney there cartoon me? He's wearing my glasses, he has my bangs, he's negging an unwilling civilian while waving around a boring amount of paperwork. The guy is more me than I am. And while at best an objectively hunky cartoon, lecturing you on your finances is annoying, at worst, it can be actively insulting because the assumption in these courses is that you are in this position due to reckless personal behavior. But imagine how that argument feels if you, like this woman, went bankrupt after having to leave your job to take care of your son who died from cystic fibrosis.
In September, we sat down to take the credit counseling course, and it was sort of a slap in the face, honestly. And we have not yet finished that course. We logged off and needed to walk away from it for a little while. And we'll need to do it again after we actually go through the filing process and meet with the judge. It's a requirement after you file.
So I'm going to put a really common misconception out there that you actually meet with a judge in bankruptcy. You don't have to go in front of a judge. No one interrogates you. There's no crazy courtroom scenes. You do have to have a meeting with a trustee, and that takes place after you file the case. But this idea that you're in a courtroom with a judge is not a typical bankruptcy scenario for most people, unless there's a hearing. Chapter 13, more often there may be a confirmation hearing. But this poor lady, I feel for her as a mom who has kids, having to go through that credit counseling class telling you you shouldn't get in this situation again is heartbreaking.
As well, so that you can, I guess, get an idea of how to not do the same thing again in the future. So, which is an incredibly hurtful idea that I'm not looking forward to.
No, of course you're not. Because having a course suggest that there is a way not to have your child die again in the future is a fucking insult. And it is terrible that she not only had to go through that, but then had to rehash it in the Senate in an attempt to get that requirement changed, which, by the way, it wasn't. And the truth is, so much of what is wrong with our current bankruptcy system stems from that 2005 law that I mentioned to you earlier, expanding the non-dischargeability of student loan debt. That was in there. The mandatory credit counseling classes, that was in there too. The law also made bankruptcy harder to complete, adding over a dozen ways that someone could make a technical error and be dismissed. It was a huge win for the credit card companies, and for all the assurances from Grassley and others that it would target high-income people abusing the system without hurting those of lesser means. After it passed, bankruptcy filings dropped disproportionately in poorer neighborhoods, with filings there decreasing 32% more than in rich ones, showing that, as always, when things are designed to become harder for everyone, for the rich, they just become a bit more expensive, and for the poor, they become basically impossible. But the fact is, something big needs to happen here, because we badly need to get our broken bankruptcy system working again for people who desperately need a lifeline. And meanwhile, while we wait for Congress...
I will just jump in here and say that I am not totally convinced the bankruptcy system is completely broken. I think if people actually felt comfortable figuring out what they can do and their options and using them. I talk to people every day who are like, I don't want to file for bankruptcy, and it's fine. I don't talk people into it, but it's because of some misconception they have. And so I think if people actually understood what their rights are, what their options are, and used the system instead of listening to what the media says about bankruptcy, that a lot of the system would actually work.
The very least we can do is offer an alternative credit counseling course that isn't quite so insulting.
Thank you for watching this. Like I said, I'm glad that John Oliver was talking about a very difficult topic and that he had some good information. There were a lot of videos in there that were 30 years old and things have changed, but I would like to say that my clients have been very happy when they've gotten through the process and they've gotten their discharge, or we've gotten the result that we need to get them back on track. And this idea that bankruptcy is a bad decision or should be stigmatized in some way is what the system wants you to think. So take that with whatever you want to take it with, but thanks for listening. I'm Jen Lee with Jen Lee Law.